Hi there, this is Kaushik Ranchod from the Ranchod Law Group. Welcome to our immigration show. Today we are going to continue our series on I-601A waivers, so you'll want to stay tuned and watch till the end because we're going to have two case studies here. One where the client was from the Caribbean and two where the client was from Mexico. We have different qualifying relatives. Well, same qualifying relatives, but in one case we talked about also the daughter, the parent, so you will want to see how we tied that in. So you might be asking, well, do I qualify? Like, what's involved? Great question. And if you haven't already, make sure you smash that like button. Post your comments below too, part of our community. So we'd just love to get your feedback. Make sure you subscribe so you can continue to get updates. All right, let's dive into it now. First of all, let's talk about the I-601A waiver process. Now I'm talking about the I-601A waiver, not the I-601. The I-601A waiver allows you to do is apply for the waiver in the United States. This was passed by the Obama administration, so basically you know whether or not your waiver is approved before you leave the United States. Previously, you would have to file the I-601, which you can still do today, but if you wouldn't have to file for it, you wouldn't want to, because you're filing for that outside the United States. Now, before the waiver, what do? You have I-130 filed for you. So after that, the I-130 validates whether or not you have a bona fide relationship. After that I-130 is approved, then you move on to the second step, the waiver. That is the process where the rubber meets the road, because you have to demonstrate that you, as a U.S. citizen, would face extreme hardship if you were separated from your spouse, or not just spouse or parent. So we're going to go into the qualifying relatives in a second. But if you were separated or had to go back to the home country. So that is where we like to provide extensive work with you on obtaining extensive documentation that supports your specific hardships. Also, we'd like to prepare a very thorough argument to demonstrate the hardships as well. After that's approved, then we move on to the National Visa Center processing, where the U.S. citizen must demonstrate that you meet the affidavit of support requirements. We also complete the DS-260. Then you also have to provide other documentation. And after that, finally, you'll have the interview at the U.S. Embassy. And then after the U.S. Embassy interview, eventually all of that, the goal is for you to get your green card. So when you come in, typically you're stamped with a temporary green card stamp, and then you'll get your green card in the mail. So that's the whole process in a nutshell. So you can get a bird's eye view of like, what are the steps that you participate in. Now, the question is, do you qualify? Another great question. So, in order to qualify, you need to have a U.S. citizen spouse or a lawful permanent resident spouse, or a U.S. citizen parent or lawful permanent resident parent. Let's talk about some specifics, what worked for some of the cases that we were able to get approved. So the first one I'm going to be talking about, a client where they were from the Caribbean. Now, the client entered in 2003, ended up getting married in 2007, and together they had 3 U.S. citizen children. So the 3 U.S. citizen children are not a direct relative. However, arguments can be made how that indirectly affects the U.S. citizen. We also argued financial hardship. So in this situation, we argued the financial hardship in this specific situation because the U.S. citizen spouse had gone to a very expensive graduate school. And when you go to expensive graduate school, you also get very expensive loans. So they had amassed a large amount of loans, and because of that, there would be financial hardship because there's no way that the client could pay that money back if they went back to the client's home country. Another factor that we argued is the fact that there would be issues with medical coverage, because here in the United States they receive medical coverage, but they would not be able to get that medical coverage if they were to go back to their home country. So that was another argument, which is really important. Medical insurance is paramount to making sure that if something goes wrong, you're going to be able to be covered. And then also, we also like to look at your particular home country. Typically, many of the clients that we file applications for, their home country's healthcare standards are not adequate and definitely not to the same level as the United States. Now, in this case, we also argued mental health hardship. So the reason we were able to argue mental health hardship is because the U.S. citizen spouse was suffering from anxiety. And typically what happens with a trigger event like this is that anxiety increases, which we were able to argue that successfully as well. Now, another argument we were able to make was the fact that both parents were co-parenting. They required the parenting of both of the parents to take care of their kids. So that would not be able to happen if they were separated as well. So all of those arguments combined, boom, we're able to get an approval. Now, let's move on to the second case study where the client was from Mexico. The client entered in the 2000s and the client was self-employed. He was married to a U.S. citizen spouse and they had a U.S. citizen daughter, so you'll see similarities to the past case too where they had a U.S. citizen child as well. You don't have to have a U.S. citizen child as well in addition to the spouse. It's just another factor for us to talk about when we're making an argument. We also argued hardship to the U.S. citizen spouse's career. So the U.S. citizen spouse was attending school. That school would be disrupted and she would not be able to get the same kind of education if she had to go to Mexico, so we were able to make that argument successfully as well. Another important factor was that the client was also taking care of her parents as well. So this is home ties, and although the parents in this situation are not direct qualifying relatives, the fact that she was taking care of her parents is a hardship argument to be made because family ties would be disrupted if she had to leave the United States. So we were able to make all of those arguments to get a successful approval. You'll see that every case was unique, but you would also saw some similarities. We argued financial hardship in a little bit of different ways. We were also able to make arguments based off of disruption to school in one case, and in another case, a little bit different. In this specific case, we were able to make the argument that family ties would be disrupted. So every case is unique, and what we like to do is just look at all of your unique factors in order to build a successful argument. So I hope this video serves you, and I will see you next week. Thank you for being amazing. Thank you for tuning in. I will see you next week. Bye for now.